Thank you for viewing this innovation blog brought to you by Prosecutors Center for Excellence and Equitas. My name is Sophia Roach, and today we will be discussing Arizona's statewide public-facing officer disclosure database. With us to provide an overview of this innovation is Sheila Polk, who has been the elected county attorney in Yavapai, Arizona since 2000. Her office is charged with both the prosecution of crimes and providing legal counsel for the county. Now, prior to her election, Ms. Polk prosecuted serious felony crimes in Yavapai County, and she also served as a deputy attorney general for the state of Arizona. She is currently the chair of the Arizona Prosecuting Attorneys Advisory Council, who helped develop this database, which allows the public to research names of law enforcement officers who've been subject to some type of discovery obligation. Welcome.
Welcome to you. Thank you for having me on your program.
Thank you. Can you please tell us a bit about the public-facing database and what you had hoped to accomplish with it?
Sure. Let's start with what the Arizona Prosecuting Attorneys Advisory Council is. The acronym is APAAC, and that is a statutorily created body that our primary mission is to provide training for Arizona's, we have more than 900 prosecutors across the state of Arizona. The statute creates an actual council, and membership on the council is by statute. So all 15 county attorneys, as well as our attorney general, we have prosecutors from our major municipal jurisdictions, and then a representative from the Supreme Court and from our law school. So our council made the decision back in 2016 that we should have a statewide database that captures and reports out information relating to officers, credibility, and other issues that we have to disclose in our criminal cases, typically known as our Brady obligation. And the reason we made that decision is that Arizona, like every other state across our country, those what we historically have called our Brady list, there's not any other state with a statewide database like we have. But number two, we tend to have those in a variety of forms, a variety of processes by which an office might make a determination that an officer should be on that list. And so there was not a uniform process, nor was there a way to share information. So the biggest issue for prosecutors across the country is, even though the officer is operating now in my jurisdiction, I'm obligated to disclose any information that could be potentially exculpatory, including information about an officer's discipline from another jurisdiction before they move to my county, and other than, literally calling up another office in Arizona to say, hey, any issues with this officer, we haven't had a good way to do that. So we decided as a council that it would be a worthwhile project to try to create one statewide database, and also to try to create best practices or uniform practices across the state for how officers end up on the Brady list, or what we now call our disclosure database.
Now, you've mentioned the members of the advisory council. Did you include others in the development of the final product, or was it something that you were able to get through with the group that has administered the site?
We included others. We started by forming a work group, and I actually tapped my chief criminal deputy for this office, the Yavapai County Attorney's Office, to chair that work group. And then we made the decision that upfront we needed to include law enforcement representatives. We knew that there was going to be some objection to this project. And so my chief deputy, he ended up for 2 years, at least once a month, holding these meetings. Attendance at the meetings was always open. So one of the issues he dealt with was somebody started attending on the 5th meeting and they had missed the first 4. But we were very focused on making sure that this was a consensus-driven process rather than a process developed by prosecutors that we were going to arbitrarily impose on law enforcement across the state.
And as a result of this collaboration, did it end up changing how your own office made its assessments of whether or not information was discoverable and what the process was to discover it?
Yes, a couple of things happened. First of all, through this consensus-driven process that had law enforcement representatives involved, we were able to hear a lot about their concerns. You know, law enforcement, the kind of the line officers, they view that Brady list as, they call it the liars list. They view it as something very negative. We had police union representatives on our work group who were very much opposed to the creation of a statewide database. At some point along the way, we made the decision that it should be public facing, and they were doubly opposed to this idea that a member of the public could just get on this database and look up someone's name. So we had a lot of hurdles like that to overcome. But in the process, in hearing their concerns, we realized that having a model protocol was really the way to go. And so we listened to, you know, they wanted the opportunity to provide input before a decision was made. They wanted notice. They wanted the right to appeal. And so we ended up drafting the protocols that APAAC ultimately adopted that essentially provide for notice to officers and provide for that opportunity to appeal. And I know we'll talk about it later, but those protocols are on the website. But the other thing that happened kind of simultaneously, or it was because we were doing this project, was the police unions ran to the legislature. Initially, they were trying to stop us. And so I can't remember the year, it was about 2018, they got one of the representatives to introduce a bill in its original form. It was going to prohibit prosecutors from having a disclosure database or a Brady list, which is an interesting idea when it's a constitutional obligation that we disclose this information. But what we ended up doing, and I personally participated, was we got ourselves involved in that legislation. I participated in a lot of the stakeholder groups. I was always looking for consensus. I was always encountering officers or representatives who didn't understand our Brady obligation. And so I was constantly educating. Ultimately, what emerged in the year 2021, legislation did pass, but we were involved in helping with all the changes. And so the legislation that passed essentially mirrors the best practices that APAAC drafted and ultimately adopted. So to me, that the great thing about it is the legislation does provide that opportunity to officers to have notice and to have input and to appeal. But it also helps develop that uniformity across the state so that every office by statute now needs to have protocols that provide for this, these essentially what officers see as their due process rights before they get listed in a database.
Well, and it's really an interesting example of procedural justice. And, officers oftentimes think about it in relationship to people other than themselves, but it works as well in their favor, and it can be really helpful in consensus building. So you've got this site, you've looked at some best practices. Do all offices in the state participate? I mean, is it optional? Is it mandatory because of the new legislation?
It is, participation is optional. Actually, one of the things that I had advocated for in the legislation is that participation by prosecution offices be mandatory, but that was opposed primarily. We had that constant push-pull where the police unions didn't want this at all. And I saw it as an opportunity to have a mandated statewide database that everyone participated in. So it's voluntary. So APAAC, we've done a lot of outreach. We have all of our major offices participate. So our state attorney general, our largest counties all participate. Out of, I would estimate that probably 75% of prosecution agencies that represent 75% of our population are participating. A number of our smaller, more rural counties are not, but we definitely continue to try to work with them to encourage them to participate.
Now, one of the things I noticed about your website is that you have, of course, the website itself with the kind of practical legal information and the opportunity for the public to search for an officer, but also a series of videos, informational videos for officers, for prosecutors, and then the one that's depicted here on best practices. Why did you include these and how important were they to the public launch?
We believe that they are extremely important. We have two purposes with that website. One is, this is the APAAC website. This is where prosecutors go for all of our information and our training. And so we wanted prosecutors to understand what the purpose of this database is and how to use it. And so that's why we have the prosecutor video. But the other thing is, I'm constantly pushing law enforcement to this website so they can listen to the law enforcement video, which is, its primary purpose is to educate police officers on what this disclosure obligation is, and to dispel this idea they all have that this is, some horrible liars list. And then the third thing we did with the website, we actually published the model best practices, which are very consistent now with the statute.
And those, of course, are available for other jurisdictions to sort through and determine if it's something they can use.
Yes, we made the decision, one of the debates in this work group was, should this database be private so only prosecutors can access this information? And you have to get past some sort of password code and then you can get this information, or should it be public facing? I was a firm advocate that it should be public facing. For one thing, these, the Brady list or these databases, they are already public record. And so the media periodically in Arizona does this request on every prosecution office. We want your Brady list. And so we all have to put up with that anyway. But number one, it's already public. And so why not have a place when the media does a public records request, we can just send them the APAAC link, here's the information. And then the other thing was, we have in our criminal cases, in our initial disclosure, we disclose any potentially exculpatory information about our police officers and other witnesses by name with the information, the normal process. But then the other thing we do is we put in a link to this website and we put the defense attorney on notice that things change. An officer, we do our disclosure and then 9 months later, the case goes to trial. And so for us, it is a sort of a stopgap measure to make sure that we are fully complying with that obligation and telling the defense attorney, this is an up-to-date website, please check it. Check all of these witnesses against us. One thing I would like to point out is this is a searchable database. This was the request of law enforcement. And in the end, I agreed with their request. So you don't just go to this website and get a list with 2,000 names.
Right.
It is a searchable database where you would have to go in, you would put in the name Sheila Polk, and it either will come up with a record or it will say no record found. And if it comes up with the record, the only information that the database gives is the identification number for that officer, if there is one, the name of the prosecution agency that entered that officer into that database. And sometimes more than one agency will have done an entry. And so there might be 2 agencies that have entered that officer into the database. That's the only information that is in that database. And we made the conscious decision that APAAC does not collect the records that support these decisions to place an officer in that database. And so the information for the agency that did is on the website, and then whoever wants the information would have to come back to the Yavapai County Attorney's Office, for example, to request additional information about that officer.
Now, for instance, if there's a prosecution in Yavapai, but the database is pointing to Brady material in an outside jurisdiction, just internally for your office, have you chosen to be the facilitator for gathering those records, or is it incumbent on a defense attorney who, let's say, finds this out without the benefit of Yavapai knowing about it? Do they have to go to that kind of custodian county?
Well, for every officer whose name we place in the database, we have the information that we looked at, and we keep that information. And there may be additional information that the law enforcement agency is also keeping. But internally, I have a committee spearheaded by my chief criminal deputy. And so any officer, any information concerning an officer that might be caused to place in that database, he will gather that information. He will provide notice to the officer that we are considering placement. He will invite that officer to provide additional information. You know, he follows the whole process that is set out in our best practices. And ultimately, then we'll make that decision. Does this officer's name belong in that database?
Okay. Have you noted any jurisdictions where there's been any conflict thus far?
I have not. You know, potentially there is the issue that my office believes the officer's name should be in the database, but perhaps the agency where that officer, you know, the county attorney with jurisdiction where the officer used to work, does not believe that the name should be there. What we set up at APAAC is that only the agency that placed the officer's name in the database can remove it. So there might be situations where one agency does not believe that that officer's name belongs in the database, and yet my agency does.
Oh, okay. And that's part of the regulations that you've set up in advance.
Yes.
Okay.
Yes.
So tell us a little bit about how the program is working. What are the benefits? What are the key utilities? I know you've described some of them here, but generally, how have your prosecutors and defense bar responded to it?
It has been a very positive experience. You know, the nicest thing was to see the shift in law enforcement from initially being quite angry with us, threatening to do videos about those of us who stood for re-election, for example, but working with them, building that consensus, helping them understand why we are doing it, was really successful. Ultimately, we were able to show them that the whole point of the work they do, if it's going to result in a criminal prosecution, if our verdict is going to be tossed out because we failed to disclose that information, then what's the point in the work that they do? And I'm constantly, not so much now, but when we first launched our database, when we went live with it, I was hearing from some of our local police chiefs, for example, concerned about it. And I was able to point them to the website, encourage them to watch the law enforcement video. And that has really been good. I think, so one of the benefits has been just across Arizona, helping to educate our police officers on what this Brady obligation is. You know, the second benefit definitely has been the ability of prosecutors to fulfill that disclosure obligation that we have. It has just been extremely difficult with officers moving between agencies, and we've got quite a bit of that going on right now. And especially moving from a large agency to a smaller agency, a more rural agency, the ability for any prosecutor, when you're doing your disclosure, check this database, and now you know that there is some information that you probably need to disclose in your case. So those have been the two biggest benefits. And then the third benefit, I spent enough time in meetings with law enforcement professionals. I really came to understand from their perspective this animosity toward this Brady obligation. And so in the end, I was very, very supportive of codifying this obligation of a prosecutor or prosecution agency, provide them with notice.
Right.
Provide them with that opportunity to provide additional information and provide them with that opportunity to appeal. Now, the opportunity to appeal is only to the prosecution agency because it's our decision. You know, it's not some court decision. So when I use that word appeal, it's in that context that they can, they can have us take a second look. And I've had police chiefs call me personally to say, I really, please take a second look, and I'll get involved and I'll bring the police officer, the police chief, and help them understand more why we are making this obligation. So I think we have, and of course, police officers, the climate at the time when they were opposing this was not favorable. The movement across the country is we need to disclose bad actors. I hope all of our listeners understand that this Brady list is not about disclosing bad actors per se. It's, disclosing anything that's potentially exculpatory. And that might be some mental health issue that an officer is having. The officer might have been involved in a car accident, now has brain injury. Well, that does go to an officer's ability to take the stand and to testify. So to me, that has definitely been a benefit here in Arizona, is just moving our profession forward in terms of being transparent, helping prosecutors fulfill that disclosure obligation, and then also just helping to educate officers on what this Brady opinion was all about.
Well, I want to thank you so much for sharing this innovation with us. And thank you also to our viewers. If you'd like to share an innovation, please contact PCE directly at contactpceinc.org. That's contactpce@pceinc.org. Thank you again.
My pleasure. Thank you for having me.